So, welcome everybody. I hope everybody has enjoyed lunch and some fresh air. That was definitely needed after tense morning session, I think. It was mentioned at some point this morning that that the financial contributions for being part of the EEA agreement are twofold. I mean, our member states, the EEA members, EFTA states, they pay into the programs and agencies that they are part of, but that's, you can say it's a bit on a voluntary basis as well. That the programs that they prefer to take part in, and then they receive, of course, back if it's a research fund or if it's a educational fund, etc. And then the second way of contributing financially is through the EEA grants and Norway grants. And that's what we are going to learn about now. EEA and Norway grants. And we have Katrin Steinfeld, Country and Bilateral Officer. They are just across from the boulevard, the small belt, or La Petite Ceinture, as we call it. And they are also moving in with us next year. So it's going to be a lot of fun having them with us. So, Katrin, please. Welcome.
Thank you.
Yeah, give me a holder. Okay.
Thank you so much for having me.
Yeah,
perfect. We like to think of ourselves as kind of the social secretariat of the EFTA family. We are the people who normally don't wear suits to work. I am probably as formal today as I can be because we're having a board meeting across the road, which is also part of the reason why I am here talking to you. Most of our management is unfortunately otherwise engaged reporting to our donors, who I will tell you more about in a little bit. I was given to understand by Torfinnur that you are quite a diverse group. I was wondering if you could give me a sense of how many of you have heard of the EEA and Norway grants before. That is quite a lot of you. Wonderful. So,
have the program.
Yes. So, in order to be sure that I don't bore you, I will go through my slides, but please stop me along the way. You know, ask me questions about topics that are interesting to you, and if it's not interesting to you, you know, you can look bored, and I will try to go faster through those slides. So, I have been working with the EEA and Norway grants in my current capacity for 1 year. Before that in my career, I worked with the grants from other places, mainly Hungary and Slovenia. You will see also in my presentation that there's quite a lot of actors involved in distributing the grants, in getting the projects off the ground, in reaching our aims, which makes it very dynamic and exciting work. So I'm, you know, advertising our office a little bit to you in the meantime. As Torfinnur mentioned, these grants are a part of the EEA agreement. They have been from the very start. We are celebrating 25 years of the EEA agreement. Back in the day, when the agreement was first entered into, this contribution was much smaller. It was much more modest, but the principles were always very similar. So, with a view to promoting a continuous and balanced strengthening of trade and economic relations between the contracting parties, we agree to the need to reduce the economic and social disparities of the regions in Europe. So that means both EEA and the EU countries. The whole mechanism that we work with is based on I think it's Article 114 of Protocol 38C of the EEA agreement, where it states that Iceland, Liechtenstein, and Norway shall contribute to reducing these economic and social disparities and to strengthen their relations with the beneficiary states. This is very important. We'll return to this a little bit later, but it's a unique feature of the EEA and Norway grants that there is an explicit goal to actually create stronger relations, build stronger relations with the European countries that we are working with in this context. Let's see. So that means the EEA and Norway grants, as grants, have two overall objectives that are both stated in the protocol. The first one, as we've heard, is to reduce economic and social disparities, and the second one is to strengthen the bilateral relations between the donors on the one side and the beneficiaries who are receiving the grants on the other side. As I mentioned, some kind of financial instrument has existed since the beginning of the EEA agreement. Originally, it was quite modest, and it was always going to those countries who were also receiving EU cohesion funds, so mainly Mediterranean countries and Ireland back in the 90s. And then with the expansion of the EU in 2004, we got something like the financial mechanism that we have today. So that was a big change with, the enlargement of the EU. The contribution also became much larger. But in 2004 to 2009, we were still talking about a project model. So we were financing projects happening in the countries that received support. And most of these projects were managed here from Brussels. Then, from 2009 to 2014, we started to have something that we call a program model. So the control of the projects and the management of the projects is happening much more at the level of the beneficiary countries, so our partner countries that we're working with. And here in Brussels now, we have kind of more of an oversight and planning function where we provide support to planning the programs, to setting the priorities for the programs together with our partners in the beneficiary countries, and then they are responsible for managing open calls for proposals, for example, and following up the actual project on the ground. So today we are in the 2014-2021 mechanism. This is a 7-year mechanism. It's quite a bit longer than previous ones have been in order to be aligned with the European structural fund cycle. So we are seeing kind of a gradual alignment with the timing for the grants with the EU funds. Just to make the structure a little more confusing, we have two grant structures. We have the EEA grants, which cover 16 or 15 beneficiary countries, depending on whether you count Spain, which is only receiving some partial funding at this point, as their GDP now exceeds the 90% threshold that you need to be below in order to receive support also under the EU funds. And both Norway, Iceland, and Liechtenstein contribute to the EEA grants. The percentages are probably a little too small for you to see from there, but Iceland's share into the EEA grants is 2.68% of the funds for now 2014-2021. Liechtenstein contributes 1.06% of the funds in this present mechanism, and Norway contributes 96.26% of the EEA grants in this period. The numbers were slightly different in the previous period, and these contributions are calculated based on GDP. So they are adjusted regularly as the GDPs of the contributing countries evolve. And then we have the Norway grants, which is the second strand. It's only present in 13 of our beneficiary countries, and Norway provides 100% of the financial contribution to this. Now, you impressed me with how many of you have heard of the EEA and Norway grants already. What is really fun is if you ever go to our beneficiary countries, you'll discover that most people have heard of it there too. And this is an enormous opportunity for building relations for our donors. And even the names of EEA grants and Norway grants are, in that sense, building closer relations, raising awareness of the common projects that we are undertaking, and in a small way also contribute to building our relations through these mechanisms. As you will see, the allocations are slightly different. So 1.3 billion euro for the Norway grants for this period, and 1.5 billion euro for the EEA grants for this period. So we are talking quite significant sums of money. You can see the breakdown per country. The biggest beneficiaries are Poland and Romania. This is also calculated per size of the beneficiary country. So the bigger countries receive bigger allocations from the funds as well. And I should maybe have mentioned earlier, but both the total sums for each of the financial mechanisms and the country breakdowns, how much money each of the beneficiaries will receive, is agreed in negotiations with the EU every time we enter into a new period of financing. As are the areas of support, because this money is tied to quite an extensive program. We are hoping to support innovation, research, education, and competitiveness. We are hoping to support environment, energy, climate, and low-carbon economy, justice and home affairs, which is very unique because that is an area where there are no targeted EU funds. Then we want to support social inclusion, youth employment, and poverty reduction. And finally, culture, civil society, good governance, and fundamental rights. And all of these areas where the money can go as support is agreed in very broad consultation. So when the next period is coming, stakeholders in Norway, Iceland, and Liechtenstein are involved, stakeholders in all of our beneficiaries are involved, and then finally it is agreed with the EU what the grants will support in the coming period, looking at what the EU already supports and looking for complementarity and synergies rather than direct overlap, although of course it's extremely important that we are in alignment with the overall goals of the EU as well. So here you can see an approximate representation of how much is allocated to the different priorities that we have set. Innovation and research receive a significant allocation. It's probably the biggest one that we have. Then environment and energy and cultural, civil society, and good governance and fundamental rights are approximately the same size. And social inclusion, justice, and home affairs are also of comparable size. Stop me if you have any questions, anything at all. It's hard for us to talk about what we have achieved in the present mechanism because at the moment we are just finishing signing all of our program agreements. We're expecting to have around 100 program agreements in 15 different countries, so that's quite a lot of different programs. And the actual projects are only getting off the ground as we speak. So we have a very exciting system for following up our results and reporting to both of our donors and the general public on what's been achieved in all of our programs. But at the moment, we only have the goals of the programs and the projects, which from what we have planned to date are already quite ambitious. So we're hoping to see 600,000 tons of CO2 either saved or reduced every year in the coming period. We want to train 600,000 professionals. We want 185,000 people to benefit from new or improved public or social services. We want to reach 12,300 Roma with empowering measures and getting them more integrated into communities, giving them a voice, giving them space to speak on issues that concern them directly. and we want to support around 2,400 civil society organizations. So, as you will see, these are 54 concepts that this is based on. We will have 100, so these goals will adjust themselves as we sign with all the countries, but we hope that this will be one to watch, definitely. We also, like I mentioned, have the second goal, not just of reducing economic and social disparities, but also building relations with our beneficiaries. And we hope that we'll have 960 projects that are implemented in cooperation in all of the countries, either with someone from Iceland or Norway or Liechtenstein, so that we will have kind of people-to-people transfer of knowledge and experience, and they can build relations also for the future, and hopefully come up with some shared results that they can build on. We want to support over 3,000 student and staff exchanges. And we want to see 180 joint articles submitted for peer review, which is quite ambitious. These are our research programs, and they are perhaps the ones that are the most ambitious in trying to build relations between researchers in our beneficiary countries on the one hand and the donor countries on the other hand. They have a goal of having bilateral cooperation in 100% of all of their projects. So this is a very special field. Researchers are normally very used to cooperating internationally and being involved in international research projects. So this is a very special sector for us. But it's a bit easier than the EU funds supporting research, as you only have to have one partner. Normally, in EU funds, you have to have several partners from several different countries, which creates bigger projects and more coordination. And we try to promote the EEA and Norway Grants research projects as a more low threshold international experience for those who might want to participate in more complex international cooperation in the future, which is what Horizon 2020 requires. Then we have some funds that are managed directly here from Brussels. So they are much, much smaller. We have a fund for youth employment. The added value of having this separately is that we are able to set different thresholds for eligibility. That means normally, in order to provide support to programs to our beneficiaries, they have to have a certain GDP, below a certain GDP level. When we are talking about the Fund for Youth Employment, we are able to target more specifically those regions who have very high levels of youth unemployment, regardless of what the country's overall GDP might be otherwise. So we have already got almost 30 projects contracted. This is much smaller, I want to repeat, so we won't have a lot more than this. This is what we're going to be having in these funds. But we have quite a lot of involvement from Norwegian partners, and we want to increase the employability of over 25,000 young people and create more than 5,000 jobs, which is very ambitious with 30 projects, or less than 30 projects. The same goes for the Fund for Regional Cooperation. We again have a different eligibility scope here. We're able to reach not only our beneficiary countries, but also countries that are in their neighborhood. So bordering countries that might not be EU member states, for example, are able to participate as partners in these projects, which is very exciting for countries that are hoping to get more integrated with the EU, such as Moldova or Ukraine or Serbia, accession countries or association countries. We are still in the process of selecting the final applicants for these projects, but we had more than 700 applications for quite a modest amount of money, so clearly the demand is very much present. And then we have a particular instrument that we call the bilateral funds, which is money dedicated to building bilateral relations with our beneficiary countries. So we have a 2% allocation of the overall amount that the grants have is supposed to be dedicated to activities that will either support, partnership searches, matchmaking activities, allowing different stakeholders to meet ahead of open calls to facilitate potential joint projects, or they go to strategic initiatives that, for example, Romania and Iceland decide that they really want to do together, and that is loosely related to the goals of the grants that are happening, but might not very easily fall into any of the programs that the country is currently implementing. So then there is scope for a little bit of flexibility to go maybe beyond what is defined in the programs as a goal, but build on that and extend that with some modest funds. How does it work? Yes, this is us, very user-friendly. So we have our donor states, who are Norway, Iceland, and Liechtenstein. They are represented by their ministries of foreign affairs when we are talking about managing these grants. The donor state embassies in all of our beneficiary countries also have a role in following up what is happening with the grants, being a contact point on the ground. Sometimes they're able to attend meetings that maybe it's not possible for the capitals to go to. Then we have the FMO, which is where I work across the street, the Financial Mechanism Office. We are the secretariat supporting the implementation of the grants. And then we have our stakeholders in the beneficiary countries. The national focal points are usually the ministries designated by our partner countries to be the main contact for managing the grants in their country. So we have one focal point in all of the countries we work with. And they are a direct liaison for their program operators. So we have countries where we have 3 programs only depending on their size. So for example, Cyprus has very few programs. It's a relatively small country, whereas Poland has 11 programs, being the biggest country. So that means we would have something like 11 program operators in Poland. And then where the action happens is, of course, at the project level, and there we have all the project promoters. Just as a comparison for you, in the last period, 09-14, we supported almost 7,000 projects, so then you would have almost 7,000 project promoters across the board. We also have some very important stakeholders from the donor side, which are contributing to mutual capacity building, learning, exchange. These are, on the one hand, our donor program partners. We have 21 public institutions in the different donor states that are contributing their expertise in the field, for example, of justice and home affairs. So if we have a program on asylum and migration in Greece, then it would be the Norwegian Directorate for Immigration that would be the contact point for these programs in the donor states to have exchanges on experiences. How is this handled in Norway, for example, compared to how it's handled in Greece? And is there any learning that can be done and any challenges that it's possible to tackle together? So they work together on the program level in designing the programs. And then we have the project partners who are then involved from Norway, Iceland, Liechtenstein in the individual projects that are initiated in our beneficiary states. What have we achieved? Like I mentioned, this applies mainly to the 09-14 mechanism because our achievements to date are a little bit in the making, let's say. So in the previous mechanism, we had a program on green industry innovation, and now I suddenly wish I had my cheat sheet, Torstein, because I had all these beautiful project examples, and I don't think I can see them here. Here we go. All right, they come up. I'm sorry. So we have 31 technologies that were commercialized in the previous period. We created more than 1,000 permanent jobs and 200 technologies that were developed, all targeting greening of existing industry. So in some cases it was about trying to get more green solutions for a business that already exists, or really coming up with completely innovative solutions to problems that businesses had. Woo, no. We had one great project example that stemmed from, I believe, Estonia, where a bus company developed an electronic system for tickets. And it turned out to be such a successful project that this solution was then in the end bought by the Norwegian public transport company and introduced in Norway, I think, either at the end of last year or this year. So you see the kind of mutual learning and mutual development that we're trying to support by learning from each other's experiences and innovations. In the energy sector, we had 169 enterprises developing technology that would benefit the environment. We managed to reduce or avoid 525,000 tons of CO2 a year. And we invested in more than 100,000 megawatts of renewable energy also per year. And this is an area that's fun to work with, as our donor countries, particularly Iceland and Norway, have quite a lot of expertise in developing renewable energies and in using them, which is a great area for mutual exchange. Oh. So we have had lower carbon emissions, plenty of research and scholarship programs that I mentioned are very ambitious on the bilateral exchanges. More than 1,000 scientific publications that were published internationally, which is quite an achievement. We had supported more than 1,000 PhD students and postdocs, and we've had more than 384 institutions cooperate among the beneficiaries and the donors, which is also a number we are happy with and that we hope to again support similar targets in the current period. Then we have the justice sector, where we've trained 90,000 professionals, either in the police, the correctional services, judges. We have the immigration services included in this. More than 250,000 persons have received legal advice or support, and almost 16,000 victims of domestic and gender-based violence were able to receive support services thanks to projects financed by the grants. Oh. So we had projects where we had secondments of judges to the European Court of Human Rights, for example, that then would strengthen human rights knowledge and awareness when they came back home in their own court systems. In the health field, we've had 2 million persons receiving improved health services, which is quite significant. 14,000 students and professionals trained, and 70 targeted interventions to reduce health inequalities, which are very important inequalities to address. There are lots of underserved communities that don't access health care, don't manage to reach these services. So again, in order to be as complementary as possible to other funds and other financing possibilities that exist, the grants try to be targeted in how they make the funds available and what they support, so that all communities are reached. So there was a project, I think it was in Romania, to strengthen tuberculosis treatment, which resulted in significant reductions in the incidence of tuberculosis in the areas where the interventions were made. Civil society, very fun area of support. This is indicative, of course. The projects that were financed by the grants reported 330 either laws, policies, or practices improved or changed as a result of their project and advice and intervention. 250,000 citizens getting human rights support, and 430 NGO networks and coalitions developed as a result of the projects that were financed. So I'm sorry that some of my project examples kind of disappeared for you, but if you have any questions to any of this, I'll be very happy to answer. Yeah.
Thank you very much. My name is Laura Woodward. I'm Romanian born, but I live in London and I'm a charity worker. And my question is, what is the input from the national governments when you decide on the priorities regarding the projects? Thank you.
Yeah, thank you for your question. We didn't go into, am I okay for time? Sorry. Yeah. Okay. We didn't go into the whole negotiation process, but what happens after the EEA agreement is renegotiated with the EU to decide how big the allocation should be to all of the countries and what the overall objectives should be. Then we have another round of negotiations with each country that is to receive these programs. And these are the so-called Memoranda of Understanding, MOU negotiations. And we have the programs that the country chooses to invest in, established in those Memoranda of Understanding. So there is another level of dialogue after the EU and the donors have agreed, where all of the specific programs are established that, for example, Romania would like to invest in, taken from the available options, of course, that were agreed as an overall objective with the EU. Does that answer your question?
Yes, so as I understand it, is the manual, there is some sort of manual
Yeah.
agreement between the donor states and the EU.
Yeah.
And the national government has to say, I would choose
Yes,
this.
we need this and this, we already have this, we are financing this from something else, so for us it would make sense to have this kind of composition in our portfolio. Mm-hmm. Yeah?
More questions?
Hello, my name is Ferdinand. I'm an intern at the Norwegian Embassy, and I gather that you just launched a few programs in Poland.
Yeah.
And I was just wondering if you could tell us something about those programs, what they're about.
If I remember correctly, which programs did we have the launch event for? It was health. My goodness, you're really catching me out here. It was the health program, for sure, but I'm not sure I remember the other ones.
They just
Do we have Google?
they just launched a very nice website, so I'm sure.
Yeah.
Yeah,
It's on our website, so I'm sure we can get it up. Our communications people are very proud of the website, so if I'm able to tell them I used it, I'll get extra kudos for that. My goodness.
Mm-hmm.
If you just go on the... No, I think the general link. Sorry, here. No. Oh, you're wonderful. Thank you.
Culture, business and innovation,
Health, home affairs. Okay, so the culture program is very exciting. There's going to be a lot of bilateral ambition to have to have Norwegian and Icelandic and Liechtensteinian arts actors involved. The Norwegian Arts Council has been very active in this program, and they're aiming to continue cooperating, for example, on the Jewish cultural heritage, which was already a priority in 09-14 and is continuing in the present period. The Home Affairs program is dealing more with police cooperation. There is a particular focus also on something that the Polish colleagues find very difficult to tackle, which is actually traffic accidents in Poland, and they wanted to have some exchange and learning from how this is avoided and dealt with in the donor countries. Then we had the health program. I believe that's the one where there's earmarked funding also for cancer research, which was already an important project launched in the previous period, and this kind of cooperation is continuing. And then the business programs will, amongst other things, have a focus on women's business innovation. So they want to support a women's network of entrepreneurs to give them a hand up, how they can develop their businesses, how they can, in some cases, even start their businesses. So there's going to be some gender equality focus in those programs too. Thank you so much to the lady who found that for me. Okay.
Okay, maybe one last question?
Yeah.
Hi, my name is Asta. Thank you very much for your interesting introduction. Just one question. The cycle now started in 2014. It will end in 2021. The programs are just kicking off now. So are they all short-term programs that will be ending in 2021? And then how does that work?
Thank you for your question. No, no, they're not short-term programs. The reality of these financing cycles don't correspond to the numbers that they are officially running under. The 2009-2014 period is not closed yet. So the projects all finished, I believe, in 2017 for that period. And we are still doing some financial reporting and follow-up for those projects that were very, very late in finalizing and that need to be closed. Whereas I believe the agreement with the EU for the 1421 mechanism was only reached in 2016, something like that. Mm-hmm. So then the whole cycle gets a little bit delayed because of these time lags. The previous mechanism is also late, so we normally don't have a corresponding period to what you see on the cover of the book. But the projects can run up to 2024 in this present period. So they have a bit more time still.
All right.
Anything else? Okay. Thank you so much for having me.
Well, biggest thanks to you and to your team over there, and looking forward to the competition, of course. Yes, so let's go on with the program. We have, as I mentioned this morning, we have this new publication just a couple of months ago, legal notes by the Secretariat on the EEA agreement. It's on the two-pillar structure and adaptation texts. And we would like to call the two-pillar structure actually the backbone of the EEA. And it's also the phenomena that makes the EEA unique in terms of agreements, other agreements. And here we have a new head of EEA legal coordination, Finnur Þór, and Carolina Lundtoft next to him. And they are going to present these, the two-pillar structure in in detail. Maybe do we need 2 microphones, or how do you want to? Yeah? Okay. Okay. Just remember to speak straight to the microphone. Okay. All right. And I will find the presentation.
Yep. Okay. So, good afternoon. I'm speaking straight into the microphone. It's working? So let me just cover my things here. So yeah, as Thorfinnur said, my name is Finnur Thor Birgisson. I'm the new head of EEA legal coordination here in the Secretariat. What we are going to do here is to present the two-pillar structure of the agreement. And like he mentioned, we will be 2 of us. The division of tasks between us is that I will kind of start by giving a general presentation of the two-pillar structure, and then Karina will go into more specific examples of issues that we have had to deal with in that context. What I will try to do is to give you a kind of background on why the contracting parties to the agreement decided to set up the two-pillar structure, and what are the main challenges related to the two-pillar structure. And then, like I said, Karina will follow with more concrete examples. So, what I will start with to raise the question, why does the EEA need an institutional structure to begin with? And in general, most international agreements actually require some kind of institutional framework to allow for dialogue and exchange of views between the parties that are between the countries that are parties to that agreement, and in some cases to allow for settlement of potential disputes. But there are two distinct characteristics of the EEA agreement that actually underscore the need for a special institutional structure even further, and that is the homogeneity principle and the dynamic nature of the agreement. First of all, we need some kind of an institutional structure to ensure that EEA law is implemented, interpreted, and applied uniformly across the EEA. Internal market rules have a direct relevance for individuals and businesses, while it's up to the national authorities and domestic courts of all the 31 EEA countries to apply and interpret these rules on a day-to-day basis. To ensure that they are doing that in the same manner, there has to be some kind of a framework to achieve uniformity. And then secondly, the institutional structure is needed to allow for the new internal market legislation to be made part of the EEA. When the EEA was negotiated almost 30 years ago, internal market legislation that was in place then was made part of the agreement, but as time has passed, much of that legislation has been amended and revised. It is therefore also necessary to update the agreement regularly to take on board these new rules, and that has actually been discussed here already, but such updates also need to respect the fundamental structure of the agreement, including the two-pillar system. So this is why we need an institutional structure to begin with, but then the question raises why a two-pillar structure? And there again, some of the distinct features of the EEA agreement come into play. First of all, it establishes that objectives of the agreement were to be met without the transfer of legislative powers to a supranational institution, which makes the EEA then, of course, fundamentally different from the EU. Secondly, it lays out that there are supposed to be 2 separate and independent pillars, one on the EU side and another on the EFTA side. And this two-pillar system was influenced by 2 concerns. First of all, the EFTA state had, of course, to consider their own constitutional framework, which precluded a solution where decision of EU institutions would be directly applicable to them. And then secondly, the EU was concerned with protecting the autonomy of its own institution. That meant that transferring competences that was exclusively in the hands of EU institutions to common EEA institution was not acceptable for the EU. So the conclusion of this was to establish this two-pillar structure. Now, the legal framework of the two-pillar structure is established in Part 7 of the EEA agreement. In Chapter 1 of the Part 7 of the agreement establishes the joint institution of the agreement, the EEA Council, the Joint Committee, the Parliamentary Committee, and the Consultative Committee, and this has been discussed earlier. Secondly, in Part 3 of the Chapter 3 of the Part 7, it provides that the EFTA states should establish an independent surveillance authority and a court of justice. And the EEA agreement only provides for the obligation by the EFTA states to establish the two institutions. The actual establishment of them is done in a separate agreement between the EFTA states, the surveillance and court agreement, which has also been mentioned here before. And to complement the surveillance and court agreement, the EEA EFTA states have concluded another agreement, which is the agreement on the Standing Committee. And the Standing Committee is an additional EFTA institution that is established by the EFTA states that serves as a forum for the EFTA states to consult and coordinate their position before meeting with the EU side, but also can be given some specific tasks under the two-pillar structure. Now, you've seen this slide or this picture before that kind of visualizes the two-pillar structure. And I'm not going to go into detail of this, but it is important to look into, to kind of reflect that on the EFTA side we have certain institutions that are supposed to reflect the similar roles of the EU institution. And then we have in the middle we have the common institutions that then have the roles that are specified in Part 7 of the EEA agreement that I mentioned before. So, as has been repeatedly mentioned here, the main objective of the EEA agreement is a homogeneous European economic area. And then the question, of course, arises, how is homogeneity maintained in a two-pillar system? This is, of course, a continuous effort, but in this context, this question can be assessed from two angles. First of all, is the more general question of maintaining homogeneity in a two-pillar system. This is, of course, crucial, and here the EFTA Surveillance Authority, in cooperation with the EU Commission and the EFTA Court, play an essential contribution. Both of these institutions have already given their presentations here, so I'm not going to dwell on this point, but rather draw attention to the issue that will be more the focus of our presentation here, which is the second angle, and this is how to maintain and respect the two-pillar solution when new EU legislation is incorporated into the agreement that give EU institutions certain tasks or competences that needs to be mirrored on the EFTA side. Now, EU acts that are incorporated into the agreement vary, of course, a lot. And some of them entail that particular EU institutions are given specific tasks or competences. When these acts are incorporated into the agreement, it must also be decided which institution or body within the EFTA pillar is supposed to take on these specific tasks and roles vis-à-vis the EFTA states. It depends on the specific task, what are the appropriate bodies on the EFTA side, but this is usually the EFTA Surveillance Authority, the EFTA Standing Committee, or in some cases national authorities in the EFTA states. In some cases, as we will discuss more in detail later, the EEA agreement already has a provision determining how to allocate such tasks or competences, and this is either in Protocol 1 to the agreement, which is a very fundamental part of the agreement, and all acts must be read with Protocol 1 in mind, or in case of certain sectors, the specific annexes the EEA may provide for the adaptation, the two-pillar adaptations that are relevant for each sector. But in other cases, the EEA Joint Committee has to decide how to address these tasks or competences on the EFTA side in a decision incorporating such new EU legislation. And the final slide that I will cover is mention the kind of the more typical types of two-pillar issues. We have highlighted in this slide. I don't know if you see it well enough. 3 types of two-pillar issues that are often come up, and these would be the examples that Caroline will cover. But these are typical kind of typical examples of the types of two-pillar issues that we are confronting when incorporating new EU legislation. There can be legislation establishing new regulatory agencies or bodies, acts that entail competences to impose fine or financial penalties on individual or private entities, surveillance acts versus regulatory acts, market authorization schemes, acts that relate to recognition of professional qualifications, and verification and approval acts. So, with that, I will give the floor to Caroline.
Thank you very much. Sorry. So my name is Pauline Mathisen. I'm a legal officer here at the EFTA Secretariat. And I will try to illustrate how the challenges that Finnur just described can be addressed in practice, and try to provide you a bit of a cross-section of examples of actual cases and the solutions, focusing on certain groups of challenges that we have identified. Sorry. But first, a little bit of a refresher. I would like to say a few words about the technique we use to address these challenges. Just a little bit of recap of what has been said earlier today. But I think it's just important that everyone keeps in mind that the challenges we are talking about, as Finnur described, in this context, they relate to the incorporation of legal acts into the agreement. Within these legal acts, there may be provisions that raise institutional questions. And in practice, what we need to do is to adapt these specific provisions so that the legal act fits into the institutional framework of the agreement. And we do this with the use of what we call adaptation texts. And in brief, adaptation texts adapt the content of EU legal acts for the purposes of the agreement. They can either amend something, they can add something to the act, or derogate from it. We have these three different categories that we talk about that Eider also mentioned earlier in this morning. Protocol 1 EEA, a very important part of the agreement on horizontal adaptations, that provides general adaptations that apply to all acts in the agreement, in the annexes to the agreement. For instance, the protocol has a provision concerning the execution of certain functions of the European Commission in the EFTA pillar. And then we also have what we call sectoral adaptations. So as mentioned before, they apply to all acts within an annex or within a given sector. For instance, in Annex 14, that concerns competition law, there's an adaptation that specifies that in that context, the term Commission shall be read as competent competition authority as defined in Article 56 of the agreement. And lastly, which is what I will focus mostly on today, we have what we call specific adaptations. These adaptations provide ad hoc solutions to two-pillar challenges, or for that matter, other issues in a specific legal act. And unlike the other two types of adaptations that are somehow contained within the framework of the agreement itself, specific adaptations are included in the decisions of the EEA Joint Committee, the JCBs. So with that just as a background, I will move on to show you some practical examples. And a typical challenge for the two-pillar setup is acts that contain a competence for the Commission to impose fines or penalties on undertakings. The EEA agreement does not itself provide for the competence to impose fines and penalties for breaches of EEA law, with a notable exception in the area of competition. So when incorporating legal acts that contain such a provision, we need to create in each case a legal basis for assigning this competence to a body in the EFTA pillar. And that can be either national authorities of the EFTA states or the EFTA Surveillance Authority. And this was the case for a legal act concerning medicinal products. Regulation 726 of 2004. Article 84 of that regulation gives the Commission the powers to impose financial penalties on holders of marketing authorizations. And when this regulation was incorporated into the EEA agreement in 2009, an adaptation text was included in the JCD with the following text. So the right to impose financial penalties on the holders of marketing authorizations in accordance with Article 84, paragraph 3, shall, in the cases where the marketing authorization holder is established in an EFTA state, be carried out by that EFTA state based on a proposal of the European Commission. Accordingly, under this Act, the power to impose penalties were vested with the national authorities of the EFTA states. However, I choose this example as it's a bit of a special case because some years later, this adaptation text was in fact changed. And that happened in the context of the incorporation of other acts in this area, and medicinal products, in 2017. And it was decided to change the setup and include a new adaptation text that replaced the former. So the adaptation text now reads, the power is vested in the European Commission in relation to the infringement procedure foreseen in Article 84, including the power to impose financial penalties, shall, in the cases where the marketing authorization holder is established in an EFTA state, be carried out by the EFTA Surveillance Authority in close cooperation with the Commission. So accordingly, the powers to impose penalties is still vested in a body in the EFTA pillar, but now it is the EFTA Surveillance Authority that has the competence. Moving on to another practical example. I mentioned earlier that Protocol 1 to the agreement contains a provision that deals with institutional matters, among other things. So paragraph 4D of that protocol reads as follows. Functions of the European Commission in the context of procedures for verification, approval, information, notification, consultations, and similar matters shall for the EFTA states be carried out according to procedures established among them. And in practice, this is a very important provision. It covers many of the typical tasks of the Commission. And consequently, when something falls under this provision, it's not necessary to come up with a specific two-pillar solution for an act that contains a task such as this. However, nevertheless, we see sometimes that it can be difficult to ascertain whether a given task is completely covered by this, or the situation nevertheless calls for a more specific solution that respects the two-pillar structure, but nevertheless ensures homogeneity, as was mentioned before. And here's a typical example of such a situation, the case of marketing authorizations. Now, a requirement to obtain an authorization from the Commission before a product can be placed on the market is something we find in many sectors. I have taken here this example from the legal act that I showed you just before, the Regulation 726/2004 medicinal products. And in order to give decisions by the Commission allowing the marketing of a medicinal product effect also in the EFTA pillar, it was necessary to create a special system. And the solution agreed upon is as follows. So when decisions on approval of medicinal products are taken according to the community procedures laid down in the legislation mentioned here, the EFTA states shall simultaneously and within 30 days of the community decision take corresponding decisions on the basis of the relevant acts. So here we have a decision to approve a medicinal product that is formally taken both in the EU pillar and in the EFTA pillar. But there's a mechanism to ensure that the decisions correspond. And this challenge of ensuring that the institutional integrity of the two-pillar structure is respected, while at the same time ensuring homogeneity, has been particularly pronounced when it comes to agencies, which I think several speakers today have talked about. And the topic of agencies has been on the agenda of this seminar in the past, and very much can be said about this, both from practical and academic perspectives. I will just try and highlight some of the challenges that we have faced and how these have been dealt with in practice. But first of all, just to know that we know that we are talking about what we mean with an agency. So EU agencies are distinct bodies from the EU institutions. They're separate legal entities set up to perform specific tasks under EU law. Now, one reason why agencies pose a challenge is that they're simply not mentioned or foreseen by the agreement. At the time the agreement was signed, agencies were not a common feature of EU law, whereas today I think there are just over 40 agencies in existence. Not all of them operate in areas that are relevant or fall under the scope of the EEA agreement, but nevertheless they're becoming more and more common. And accordingly, unlike for the competences of the Commission, where a two-pillar setup is outlined in the EEA agreement itself, there are no EFTA pillar institutions directly foreseen to take on the tasks of agencies. And simply leaving the competences with the agency itself would pose a constitutional challenge for the EFTA states, who of course are not EU members. So this is why a number of challenges may arise when we incorporate legal acts that set up an agency into the EEA agreement. And these relate to particular participation rights, cooperation mechanisms, dispute settlement mechanisms, powers to adopt binding decisions, and access to court. And just to highlight and add that it's important to note that there's no one-size-fits-all solution when it comes to these challenges. And that's simply because there are no one-size-fits-all agencies. All the EU agencies have different tasks and powers, and therefore we've had to find ad hoc solutions in each case in order to fit them into the two-pillar system of the EEA agreement. I will show some examples from the field of financial services, which others have mentioned earlier, as they prove particularly challenging. So what we refer to generally as the European Financial Supervisory Authorities, the European Banking Authority, EBA, European Insurance and Occupational Pensions Authority, EIOPA, European Securities and Market Authority, ESMA, and the European Systemic Risk Board, the ESRB. And as you see, these were all established in 2010 in response mostly to the financial crisis. They were incorporated into the agreement in 2016, so there was a significant time that passed in order to agree on solutions that would respect all the needs and wishes of the contracting parties. So these agencies together are entrusted with improving the microprudential supervision of financial institutions. They have powers to adopt binding decisions addressed at financial market participants and national competent authorities. They also engage in direct supervision and have a coordination role between supervisory activities of national authorities. And what makes these agencies special is the degree of centralization of supervisory competences from national to EU level. These agencies have the powers to adopt binding decisions addressed not only to national authorities, but even directly to undertakings. And this raised a very specific twopillar challenge. We had a dilemma on the one hand, how to maintain the advantages of a centralized and harmonized supervision while safeguarding the twopillar principle. And the solution that was agreed upon in the end is that the European Financial Supervisory Authorities, the agencies, do the technical work, but the EFTA Surveillance Authority has the formal decision-making powers as regards the EFTA states, their authorities, and their market participants. However, when the EFTA Surveillance Authority is using its decision-making powers, it's doing it on the basis of drafts prepared by the agencies. So an important feature of this setup is that the technical but non-binding tasks that the agencies are entrusted with remain with the agencies, so issuing of recommendations, mediation, etc. But the binding decisions are adopted by the EFTA Surveillance Authority when the matter concerns an EFTA state or an undertaking. And to highlight a few of the specific solutions, I picked up a few examples from the JCDs that incorporated these acts into the EEA agreement. Now, as you saw earlier, sometimes adaptation texts are only 1 or 2 paragraphs. However, in this case, you will see that the adaptation texts are quite substantial. In fact, they're several pages long. And just before I go through the examples, I'll say a few words about the language used in these adaptations. You will see that the agency in question is referred to as the authority, which is in line with the EU terminology, but is not to be confused with the EFTA Surveillance Authority, which is also mentioned several times throughout the text. Just important to keep the track of which is which. But the first example here on the screen has to do with participation rights. Agencies are typically managed by a board of supervisors in this case. And this adaptation provides that the competent authorities of the EFTA states, as well as the EFTA Surveillance Authority, shall, but for the right to vote, have the same rights and obligations as the competent authorities of EU member states in the work of the European Supervisory Authority, here ESMA, and its board of supervisors and all preparatory bodies of the authority. And interestingly, there's also a reciprocal right to participation for the agency, namely that the authority, so here ESMA, shall, but for the right to vote, have the right to participate in the work of the EFTA Surveillance Authority and its preparatory bodies when the EFTA Surveillance Authority carries out, as regards the EFTA states, the functions of the authority as provided for in this agreement. And the functions that the EFTA Surveillance Authority can carry out are, for instance, described in this adaptation text. So in situations where exclusively competent authorities of the EFTA states are concerned, and where such authorities fail to reach an agreement within the conciliation phase, the EFTA Surveillance Authority may take a decision requiring them to take specific action or refrain from action in order to settle the matter, with binding effects. And then secondly, where competent authorities of 1 or more EU member states and 1 or more EFTA states are concerned, and where such authorities fail to reach an agreement, the authority and the EFTA Surveillance Authority, so the agency and the EFTA Surveillance Authority, may take a decision requiring the competent authorities of respectively the EU member states and the EFTA states concerned to take specific action, again with binding effects. And finally, decisions by the EFTA Surveillance Authority shall, without undue delay, be adopted on the basis of drafts prepared by the authority at its own initiative or at the request of the EFTA Surveillance Authority. So as you see, this system entails that the agency and the EFTA Surveillance Authority each takes a decision for their respective pillars, but that the EFTA Surveillance Authority's decision is based on a draft prepared by the agency, thereby ensuring a homogeneous approach. So, moving on to the last example I'm going to show you today, which follows on from that and pertains to the modalities for cooperation and potential dispute resolution between the agency and the EFTA Surveillance Authority. So, firstly, the authority and the EFTA Surveillance Authority shall cooperate, exchange information, and consult each other for the purposes of the regulation, in particular prior to taking any action. And secondly, in case of disagreement between the authority and the EFTA Surveillance Authority, with regard to the administration of the provisions of the regulation, the chairperson of the authority and the college of the EFTA Surveillance Authority shall, taking into account the urgency of the matter, without undue delay, convene a meeting to find consensus. Where such consensus is not found, the chairperson of the authority or the college of the EFTA Surveillance Authority may request the contracting parties to refer the matter to the EEA Joint Committee. So here the EEA Joint Committee is established as a dispute resolution body in this context. So these were some practical examples of some of the two-pillar challenges that we see regularly. As you'll see, they're very diverse type of challenges. And as I highlighted before, most of the time we need to come up with ad hoc solutions to fit a particular situation. We obviously can draw inspiration from previous cases, but at the end of the day, each situation needs to be assessed on its own merits. And with that, I thank you for your attention. But I would like to point out, as Sorkin pointed earlier, if you're interested in this topic, our recently published EFTA bulletin from June this year contains 2 legal notes, one on the two-pillar structure and the other one on adaptation text in more general. Both these notes explain in more detail what we talked about today and contain a number of examples of the cases that I have talked about as well. And there's some copies outside on the table I saw, but it's also available on our website in full. Thank you.
So big thanks to both of you. Let's have some questions from the audience. I know it's getting a little hot in here. If we can open out the door for 5 minutes while we have a few questions. Somebody asked about these things actually this morning. Yeah, over there from Geneva. What?
Thank you very much for the presentation. I have a question concerning the dispute settlement mechanism. From what I understood, it's mainly going well, but what happens if the two pillars cannot agree on how legal text of the EU should be translated, or if this text should or should not become EA law? What's the mechanism after if there is no political agreement on that?
So, am I being heard? Or?
Yes.
Okay. Thank you. This is a very, of course, key question. There are provisions that in the agreement that apply if there is if the contracting parties do not manage to reach a consensus. They're quite complex, and I'm not going to go into the detail of them, but they can lead to a situation where part of the EU agreement might not be applied, the part that would be affected by that dispute. But this has so far never been applied. We have always managed to reach a conclusion, so there are many practical questions. What would the implication of that actually be, which hasn't really been answered because there has been no example so far.
Yes, we normally get this question actually because some people simply don't believe that there's always a way to find a political solution, but it seems to be the case now for 25 years. But as I said earlier today, that the example of the financial supervisory authorities, that took a number of years to reach on a high political level.
Maybe I can add something.
Yes.
So just to add something to that, so there's sort of two parts of the question here. One is if you don't agree on incorporating that into the agreement, Indeed, that has never been put to the test as such. And the other part, if you don't agree afterwards, how a specific legal act should apply. But there, I think the two-pillar structure indeed solves, in practice, many of these potential conflicts, because there's a great deal of trust and cooperation between different institutions. EFTA's event stored in the EFTA court that we had here earlier today. And in practice, there's not been a need to raise conflicts to the level of dispute resolution, because they are being taken care of by the institutional framework.
Yep, over there. Is it Andorra?
Thank you. Thank you for your presentation. You said that the incorporation of acts related to financial services took a long time, 4 years, I think. I have a question. Did this situation put in jeopardy the access to the single market for the EEA EFTA states? Thanks.
No, indeed, it took actually 6 years to reach an agreement on the incorporation of these acts. No, I don't believe that question came up. There was a good dialogue in all those years, and a willingness on both sides to come up with a workable solution. So no, I don't think that question was put to the test now.
Maybe just to complement that as well. I think that overall all the parties were, however, aware that there was a sort of precedent visa conclusion, and they were actually kind of very engaged in actually to find a solution on it. But the issue was also quite complex, and there was an understanding on all sides that it was complex, and it needed to be found. There was a need for found an acceptable solution that respected the two-pillar structure.
If I may add, I'm not sure if the question goes into the sort of market disruption. Of course, the consequence of not incorporating or taking time to incorporate has had negative effects on market operators, because they were dependent on the legislation. I'm not sure whether that was the question, but I think we shouldn't minimize the effect that this actually has on the financial services industry.
More questions? Everything crystal clear? We're actually quite on time as well. It's 2:45. This is fantastic. So thanks again to both of you. So we are getting closer to the end of our seminar. And here we have a new guest, His Excellency, Ambassador of Iceland, Gunnar Pálsson. Perhaps if you allow me, Mr. Ambassador, to play a couple of videos that were done in your country. They only take 1 minute each. They are sort of showing the benefits of being part of the internal market. Yeah, so if you missed the subtitles, I'm sorry about that, but please watch the smaller screens then on the side. But this was a very interesting project that received funding from Horizon, if I remember correctly. than the other one. Very different.
Ég heiti Hannes og eigandi ferðaskrifstofunnar Pink Iceland Reykjavík. Við sérhæfum okkur í þjónustu við hinsegin ferðamenn, auk þess sem við erum stærsti skipuleggjandi brúðkaupa á Íslandi fyrir fólk af erlendu bergi brotið. Aðild Íslands að Evrópska efnahagssvæðinu gerir ferðaþjónustuna sterkari atvinnugrein á Íslandi en ella. Samræmdar reglur flug gerir flugfélögum auðveldara fyrir að fljúga til Íslands frá Evrópu og frjáls för fólks þýðir að fjöldi fólks frá EES-svæðinu vinnur í ferðaþjónustu á Íslandi. Evrópska sjúkratryggingakortið og það öryggi sem það felst í því að geta ferðast með það hefur líka áhrif á það að Ísland sé ákjósanlegur áfangastaður, en kannski mitt svona uppáhalds hvað þetta varðar svo staðreynd að gestirnir okkar geta notað símann sinn eins og þau séu heima hjá sér, sem gerir okkur kleift að þjónusta á miklu betur og gerir þau öruggari á sínum ferðalögum á Íslandi.
All right, that was it. So now we have our last part of the program. Mr. Ambassador Gunnar Pálsson, please welcome. I believe you want to speak without any slides. That's of course great. We've seen too many slides, I think, today. So please welcome up here. And Mr. Pálsson is currently chairing the standing committee, as you heard already this morning.
So, ladies and gentlemen, dear friends, it is a pleasure to be with you here today as the last speaker in the program, and I've looked at the impressive series of briefings you have received so far. I have to wonder, of course, what else there is left to say. I am also keenly aware that I'm the only thing standing between you and cocktails this afternoon, or networking drinks, as they are more aptly called, and I know from experience that that is not a good place to be. I hope you won't mind if I loosen my necktie a little bit. What have you done with all the oxygen? Anyway, I want to talk to you a little bit about the work of the Standing Committee, chaired by Iceland during the second half of this year, as well as our priorities. And then, if I may, I would like to change hats for a moment and give you a perspective of one of the EEFTA states, in this case Iceland, obviously, on the EEA. So, the main task of the Standing Committee of the three EEFTA states is to agree on decisions we will adopt together with the European Union in the EEA Joint Committee. The three ambassadors of Liechtenstein, Norway and Iceland, with Switzerland and the EFTA Surveillance Authority as observers, meet about 8 times a year to discuss and agree a common position that they will present in the meetings of the Joint Committee that normally are held the following day. A key feature of the decision-making process in the EEA is that the three EEFTA states need to speak with one voice. This is in fact written into the agreement, and since we are like-minded countries, this is normally not a challenge. Still, being three independent countries, we need to make sure that we always find the common ground. This we do because it is obviously required, yes, but also because there is no denying that in our dealings with the 28 EU member states, unity is a source of strength. In this way, we compensate for our lack in numbers through better cohesion. Although this is our main item of business, as I said, agreeing decisions before the Joint Committee convenes, it is not our exclusive concern. We also use the Standing Committee meetings to discuss how we can influence proposed EU legislation at an early stage, decision shaping for short, and we receive, assess and discuss information regarding ongoing work of our 5 subcommittees and almost 30 working groups. Finally, we also exchange views and information about our broader relations with the EU at a political level. It is important to bear in mind that while the Standing Committee represents the pinnacle of the work we do among the EEA EFTA states, the most intensive and time-consuming part of the work is done outside and in between meetings of the committee. As I mentioned, an enormous amount of work is done through the working groups and subcommittees, with, as always, the excellent support of the EFTA Secretariat in the day-to-day management of the EEA agreement. In many ways, therefore, the meetings of this committee can be likened to the tip of an iceberg. Now, in addition to the work connected to the Standing Committee structure, there is a lot of more informal contacts between our delegations and the Secretariat here in Brussels, between them and our colleagues in capitals, and of course with our counterparts on the EU side, the European External Action Service, the Commission, the Presidency and the Council. This takes place at all levels. I myself am frequently in contact with my colleagues from Norway and Liechtenstein to discuss EEA issues, as well as the Secretary General of the EFTA Secretariat. It is perhaps in the nature of the work we do in the Standing Committee that its meetings tend to be somewhat choreographed. They are typically matter-of-fact-like and geared towards results. In the past, there has been discussion on whether we shouldn't loosen up the format to allow for a more free-flowing, spontaneous discussion, if you will, in our meetings, to jazz them up, if you will. And I think that we all agree that it is important for the 3 missions to be able to have frank conversations among themselves about outstanding issues, policy-related or practical, be they problems in the making or opportunities to further our cooperation in different fields. However, instead of having those conversations out in the open, we have opted for a more informal setting with the 3 ambassadors meeting for lunch a few days before the Standing Committee convenes. And this ménage à trois, initiated by our Liechtenstein colleague during the last chairmanship, has, in my view, worked out quite well. Although the meetings of the committee may, as a result, have become more pre-scripted and, if you will, predictable, I think it has also made them more productive. To make them more efficient still, our deputies, who are in any case in touch on a daily basis, also normally meet in advance. It is the Standing Committee that also sets out the priorities of our work with the EEA on the EFTA side. While there is, of course, a lot of business continuity in the work we do, each 6-month chairmanship of the committee presents a proposal on issues that will require particular attention. In the second half of this year, the Icelandic chairmanship has, to take an example, the following 5 priorities. Firstly, we want to enhance our EEA outreach efforts. We wish to take advantage of the EEA's 25th anniversary this year and promote better knowledge of the EEA agreement and financial mechanisms in other countries, but also among the different EU institutions. This, of course, is particularly important now, considering that we have a newly elected European Parliament and that a new Commission is expected to take office later this autumn. Secondly, we wish to accelerate preparations for EEA EFTA participation in relevant programs under the new multi-annual financial framework for 2001-2027. We will develop our positions on individual program proposals, and monitor developments on forecasted financial contributions. Third, and this refers back to the decision shaping I mentioned earlier, we will continue to scrutinize forthcoming EU legal acts at an early stage, pre-pipeline and pipeline issues as we call them, and submit EEA/EFTA comments where appropriate. The EEA/EFTA comment that we are submitting to the EU side this week on the single market beyond 2019 is, I think, a particularly good example of such work. We will keep a particular focus on the priorities of the incoming Commission and assess how these may affect our EEA cooperation. Fourth, we will of course emphasize our core task, which is to ensure the timely incorporation of new EEA-relevant EU legal acts into the EEA agreement. Our aim is to reduce the backlog, particularly in the area of financial services. The assessment of two-pillar challenges, and I know you just discussed two-pillar challenges just now, and finding adequate solutions in close cooperation with the EU side remains, as always, an abiding concern. And finally, while, as former UK Prime Minister Tony Blair said, all are sick of Brexit, we need to continue monitoring the Brexit process. We have prepared ourselves well for both a deal and a no-deal scenario, and will continue collaborating in preparation for any future arrangements we may wish to adopt with the UK. So those are the five main priorities. Now, if you allow me, I would like to take off my standing committee hat and speak briefly to you about the EEA from a national perspective. The EEA is certainly the most significant economic agreement Iceland has entered into. It impacts the everyday lives of my countrymen and is the home market for our businesses, accounting for around 72% of total exports. Let me see if I have, yeah. The agreement covers policy fields under the responsibilities of all ministries and requires constant updating to ensure homogeneity in the single market. Such a far-reaching, comprehensive relationship necessitates coordination across our entire national administration and, of course, in Brussels. Our mission to the EU is Iceland's largest diplomatic representation abroad. The whole team, 18 persons in all, includes, in addition to local staff, 7 career diplomats and 6 councillors representing 5 line ministries, with 2 more joining us next year from the Ministries of Environment and Health. And my hope is, of course, that by the end of my tenure, we will have all the line ministries represented here in Brussels. I should add that besides the EU, our mission is also the bilateral embassy to Belgium, Holland, Luxembourg, and San Marino. Our growing presence, which brings us back, roughly speaking, to the numbers of staff we had in the period prior to our defunct 2009 application for EU membership, reflects a determined effort by the current government to reinforce and improve the management of the agreement and better safeguard and promote Iceland's interests in Brussels. How do we do that? One thing we need to do is to identify key issues as early as possible, long before they are decided upon by the EU and are formally taken up by the EFTA structure. Equally important, we must set our own priorities, define our strategic objectives, and identify key players. In effect, being small, we need to become experts at prioritization. While it is difficult at times to assess when an effort to exercise influence has borne fruit, there is no doubt that the EEA agreement does offer opportunities, including legally guaranteed opportunities, to shape decisions and make our voice heard. At the same time, we are conscious of the fact that we have neither the same access nor institutional advantage as our colleagues working inside the EU. This demands, of course, that we work extra hard vis-à-vis the EU machinery to build networks and coalitions of like-minded states, engage the EU Parliament, and work closely with the EEAS and our EFTA partners. This, I would say, is the core task of our mission, and if you were to ask my colleagues, I suspect their account would not be much different. To sum up this part, in the past 2 years we have made a focused effort to improve Iceland's management of the EEA agreement with increased resources and administrative capacity. The results are already showing. The backlog has been reduced, and we are lowering our implementation deficit back home. However, as the old proverb goes, one swallow does not make a summer, and we are now confronted with the challenge of sustaining this effort over the longer term. 20 years on, the EEA continues to enjoy strong support in Iceland on the side of our government and among the population. According to a recent poll, only 12% of Icelanders oppose the EEA. We now have a whole generation of Icelanders with no recollection of life before the EEA, and as a consequence, there is a certain risk that the agreement will be taken for granted, and we must of course stay on our guard against complacency, which always sets in under such circumstances. When Iceland decided in the early 90s to become party to the EEA agreement, it went through one of the more wrenching foreign policy debates in our republic's history. Since that time, Iceland's membership of the EEA has rarely been subject to political debate, as most Icelanders have come to appreciate that a rise in their standard of living can largely be attributed to Iceland's access to the EU's internal market. Recently, however, we are witnessing a growing, albeit a minority, movement questioning some of the fundamental tenets of the EEA. And this is a new phenomenon for us and calls for a well-informed and a more rigorous debate on our adherence to the agreement. And as an input to that debate, we look forward to receiving, in a few days' time, a report commissioned by members of Parliament last year on the pros and cons of the EEA agreement for Iceland. As I mentioned earlier, the 3 EEA states are like-minded in their views on European cooperation. We all want to consolidate and promote the EEA agreement. But we are also individual countries with different backgrounds and political culture. This may explain why the so-called third energy package became such a hot-button issue in Iceland recently. To To give you some background, we have for the longest time been a resource-based economy where fisheries and energy, in particular, carry a strong association with notions like self-governance, independence and sovereignty, all sacrosanct for a country that celebrated its 100 years anniversary of independence last year. I am not saying that the third energy package constituted in any meaningful way a threat to our sovereign control of our energy resources. This is certainly not the view of my government. What the discussion underscores, however, is that when there are divided views among our people on issues of this nature, and after all, Icelanders produce most energy per capita in the world. I only found that out last week. Democracy must run its course. We must have a full airing of the views, answer questions, respond to criticisms, and assist participants in a discussion in appreciating how our national interest is at the end of the day best served. Now, this can be a long, hard slog and may hold up the proceedings here in Brussels as it almost certainly did this time. But if we don't go through that exercise, we risk something worse: the gradual erosion and loss of support for the EEA agreement. And it is not least for this reason, and I say that irrespective of the merits of any individual case, that we must continue discussing, defending and explaining the EEA. We must reach out to our public, and we must not be afraid to talk about challenges as well as the benefits involved in our cooperation with the EEA. So let me now conclude. Given the high stakes and the nature of our dynamic relationship with the EU, there are bound to be challenges and points of friction from time to time. There is no way around that. For example, we must continue to uphold the two-pillar structure of the EEA agreement and find solutions as powers are increasingly delegated to agencies and bureaus on the EU side. We must also stay ahead and follow EU legislation that is being prepared from the beginning, making sure in the process that we find solutions that are in accordance with the EEA agreement. We must also ensure that the impact of Brexit and the hardening of positions of the EU vis-à-vis partner countries that we might be witnessing do not negatively impact the EEA or our broader bilateral relations. Finally, we must work together to manage the impact of challenging issues outside the EEA, be they, as in the case of Iceland, related to fisheries disputes or preventing discriminatory market access for seafood products into the EU, or some other issues. So the EEA agreement has served us well. It is a stable and predictable framework of relations that brings us closer economically to the EU than any other partner country arrangement. So let us continue working on it and not take it for granted. Thank you.
Thank you, Mr. Ambassador. There must be some questions. You can even ask the same question as you asked and you maybe didn't get replied to earlier on, if that's the case.
Just keep on trying.
Yeah, depends who's answering.
So bring it on,
yes.
by all means.
been some questions about if there's a dispute between the EEA states on the one side and the EU on the other side. If an agreement is not reached, what happens? That's a question that we get all the time.
Are you referring in particular to the third energy package? Or no?
Not necessarily. No, but there have been.
What sort of agreement are you talking about?
I mean, like for instance, when the financial supervisory agreement was reached in the end, but it took many years. What would have happened if it had not been the case?
Well, of course, that is a hypothetical question, and the answer, of course, will have to be highly hypothetical also. I mean, as you know, the EEA agreement provides for the option of not agreeing to a particular act of legislation. It has never been tried out. And I think we all agree that it is not worth taking the risk of refusing to adopt EEA relevant legislation and find out what happens after that. It could make our lives very difficult. And in our own case, whenever issues come to the surface, like the one that I just deferred to, the question is asked, well, what if we do not sign onto the dotted line and reject the package? We have not chosen to take that question on directly. Instead, we focus on the advantages that we feel need to be explained in terms of our membership in the agreement, so as to make sure that our national interest is best served, as I said, within this framework. But you raise a legitimate question, whether it was you or someone in the audience. We see more and more legislation coming our way. This cooperation, especially in the economic area, is becoming deeper and more extensive. And I think we can expect, as time goes, that questions of this nature will keep coming up. And therefore, I think it is not too early to focus some attention on the two-pillar structure, not because we think it is insufficient or not sustainable. Still, we do think we could usefully take some time to discuss how this two-pillar arrangement can be better adapted, possibly, to the challenges that we see coming down the road. This is a very long hypothetical answer to your hypothetical question.
Over there, and then here. Okay, cut here.
Ambassador, is it conceivable, in your view, that Britain, post-Brexit, could join EFTA?
It is conceivable, for sure. Is it likely? No. We see very little indication from the United Kingdom that this is something they are actively studying or exploring, but they want to keep all their options open, clearly. So, do we have a position on that? Well, I think at the end of the day, our position is to respect the wishes of the British people, and then take that discussion across the bridge when the day comes. But so far, no, we see no indication that this is something they are actively considering.
Yeah, over
there. Sæll. So I have a question. You raised the issue about increasing, Euroscepticism in Iceland when it comes to, for example, the EEA agreement. Do you think there's a disconnect between people's daily benefits of the EEA agreement and the perception of European cooperation? Do you think we have a PR problem?
I think we all have a kind of a PR problem, if only because the EEA agreement is an extremely complicated document. This cooperation is being extended and it's deepening, and we have to keep working at it. And we need to do a better job of explaining to people the advantages they have in being party to this cooperation. And frankly, when you talk to people, you realize that very few of them, are prepared to consider the advantages that this agreement bestows on them in their daily lives. I mean, young people traveling abroad, not having to pay roaming charges for the use of their phones. Older people being able to retire to Spain and buying properties there. If you get sick, you can use your European insurance card to get hospital treatment. I mean, the list goes on. You couldn't do any of this if it wasn't for the EEA, and people need to be reminded of that. So yes, I think we are doing a great deal to spread the good word. I think we are doing a great deal to explain the EEA, but it's not easy, and we must always be ready to look for more effective and more concise ways of getting the message across. I don't think this has, when everything is said and done, I don't think this comes down to Euroscepticism. It's just that people in general, especially the younger generation, the people who were born after we signed on to the EEA, they are simply not aware of what life was like in the old days and what it will be like if we go back to the old days.
Okay. Further questions? No?
That's unbelievable. Well,
yes, I suppose I could ask something about the channels through which Iceland can influence EU legislation, because you mentioned being alert and kind of notifying issues that might have an interest for Iceland early on. But I was wondering if Iceland actually had a position in the Council of the European Union, and if you could contribute there.
The question was, do we have access to the Council in order to get our views across?
Yeah, I mean, once the Commission has proposed the legislation and it kind of bounces back and forth between the Parliament and the Council of Ministers.
Yeah, no, we are talking about a phase that comes much earlier than that, when the ideas are being discussed and the proposals are coming forward in expert groups mainly. Some of them quite technical. That is a challenge, because technical questions can, become political issues before you know it. So it's always very difficult to make a proper assessment early on, but that is what you need to do anyway. Once an issue floats to the surface, once it is being discussed at a higher level, the window of opportunity becomes so much narrower for us to influence the legislation. Although, as you said, there's always a chance that we can work our views vis-à-vis the European Parliament. And we've seen that. Just to take an example, we used the opportunity only 2 weeks ago to provide the European Parliament with a whole dossier of information about the so-called mackerel dispute. I'm sure you are an expert, you're all experts on the mackerel dispute. But you see, people had a wrong idea about Iceland and the mackerel. They were being told that Iceland did not want to negotiate, that Iceland did not want to engage in serious discussion with the other coastal states in sharing out the quota in the mackerel fishery. The opposite was true. We had been knocking on the door for years, and since we were not being recognized as a coastal country, we had been more or less, forced to resort to our own means and issue an unilateral quota. So we decided to take this up with members of the European Parliament, especially in the Committee on Fishing, 57 members, and that worked. And there are now under no illusions about what our standing is when it comes to the mackerel issue. This is not EEA related. However, an issue of this kind can become EEA related before you know it. How? Well, if only because people back home, they don't make these distinctions. And if the European Union is being seen as being intransigent or inflexible in dealing with us when it comes to fisheries, that also can undermine public support for the EEA agreement. And we have to be aware of that.
Yes. Okay. Further questions?
That was more than he bargained for.
No, okay. Maybe if I can, because you mentioned yourself this hot potato that the third energy package is, or was, you say it was, it's not any longer, we hope. But there was also, I don't know how hypothetical that question was, but there was this suggestion in some parties in Iceland to sort of send the package back to Europe, send it back to the Joint Committee, where you are indeed being represented. How would the Joint Committee have dealt with getting that back, because it was already incorporated?
Well, how do you get on board a bus that has left the station? That is really the question. I mean, this was signed onto, signed, sealed and delivered by the Joint Committee, and there is no question of coming back to the committee unless you want to take the issue back to the 28, soon to be 27 member states of the Union. That is a very tall order and something that has not been done before. So, yes, ideas like that come up and they should be discussed. One should not fault people for raising such questions. I mean, they are reasonable, but at the end of the day, it is totally unrealistic, I think, to come back years later to the Joint Committee and ask them to reopen something that all 28 member states have agreed on among themselves. So it was basically a question of explaining that. I'm not saying that anyone was convinced, but most people are prepared to be reasonable.
Very good. So, if there are no further questions, let's give Rick applause. So the ambassador is no longer in the way between you and the refreshments outside. So let's enjoy that in a while. Just to thank you all so much for coming. Thanks for the interventions and all the conversations. If any of you, by any chance, you've seen there have been pictures taken here. If you have any reason not to be on those pictures or in our photo galleries, please let us know. And then I would really like to thank all the speakers, Britt and Auður and Finnur and Karolina and all the others who have now unfortunately left the room, but they will be probably some of them outside. And of course, thanks to my team, Georg and Betsy here, who have helped me organizing this, and to the other trainees who have been tweeting. So if you want to recap some of the contents here, Go to Twitter and Facebook or something. You can find some of the content there. And then tomorrow or something, we will send you links with all the presentations online. So you will get everything in the end. So thank you so much, and let's enjoy some refreshments.